Recording in progress.
Yeah. All right. We'll start a few seconds early here tonight. Good evening, everybody, and welcome to the January 17th meeting of the Trinidad Planning Commission. Go ahead and call this meeting to order. So we can have a roll call, please.
Sure. Commissioner Slade.
I am present.
Commissioner Humboldt.
Present.
Commissioner Hickman.
Here.
Commissioner Johnson.
Here.
Commissioner Hopkins.
Yep. All right. First item on the agenda after roll call is approval of the minutes from the Wednesday, November 15th meeting. Are there any changes any of the commissioners wanted to make to those minutes?
I got one relatively minor thing, which is that I don't believe I said I would like to add traffic calming to future agenda items. I just was wondering, since it was a sort of hot topic at the time, whether we should anticipate traffic calming stuff coming before us. So that's under future agenda items on the very last page of the draft minutes.
You want to leave it, remove it?
Can we find something?
Absolutely. But hang on one second, Tom. Do you want?
I would just say that it's not really accurate that I would like to add it. If we would like to address it as a committee, I'm totally fine with that. But it's not something that I
So if we just update it, would like to suggested considering adding, does that work for the minutes?
That's a good question. I was just curious whether we should anticipate anything, since it was a topic of the most recent council meeting at that point. So I really wanted to add it. I just wanted to acknowledge the possibility that it might come before us or something of that sort.
Okay. And Tom, Trevor, does that make sense?
Could you repeat that again?
It does. I don't know that I wanted to add traffic calming to future agenda items. I just wanted to acknowledge that it was something that the council was discussing.
Do you think, and you said it during future agenda items?
More as a query, like should we anticipate traffic calming stuff coming before us?
Okay, that's fine.
I don't feel strongly about it. Point that out.
And then Tom?
Well, it's just page 4, the draft 4-6, in regards to Trevor suggesting the possibility of designating Trinidad scenic. The design process for reviews. The coastal act to protect visual resources and certain key characteristics. Gonna get kind of hung up on that. Can't do anything. Hopefully we can do something about some kind of visual impact.
Yeah, no, that's definitely a question. And something we'll be discussing further with the Coastal Commission.
Sorry, I don't mean to bring up a can of worms.
You just want to emphasize it. Yeah.
Okay. Anything else? Motion to approve the minutes.
I move to approve the minutes from the November 15th meeting.
Second.
Second.
All right, all those in favor? Aye.
Aye.
All right, passes unanimously. All right, moving on next is approval of tonight's agenda. We have 4 items on the agenda tonight. Any changes commissioners would like to request to the order?
I would like to suggest, as a matter of personal interest, as a matter of public interest, to swap, I guess, the order of agenda items 1 and 2, so we can address Morrison line adjustment first. Otherwise, no.
Anybody else, any objections to that? Okay. All right, then a motion to approve tonight's agenda with that change of reversing items 1 and 2.
So, second.
All right, those in favor? Aye.
Aye.
All right, passes unanimously. All right, first, next on the agenda are items from the floor. This is an opportunity for members of the public to speak to anything that is not on tonight's agenda that we're not going to cover. So if you do have anything that's not on tonight's agenda, now's your chance. Get roughly 3 minutes. Feel free to step up to the podium, introduce yourself if you'd like. All right, seems like we're all here to talk about things on the agenda tonight. And any members of the public, items from the floor? Don't see a hand up there with Ms. Provost. All right. So that brings us right into our agenda. The first item is item number 2, Morrison 2023-8 CDP and lot line adjustment. Trevor.
Sure. So So this is a lot line adjustment of 4 existing parcels. It will result in 3 parcels. It does have an existing residence located on the property and septic system. Those improvements cross a couple of property lines. So this lot line adjustment will facilitate being able to have some vacant lots that could be sold in the future and developed in the future. And it's a significantly large lot in Trinidad. It's one of the largest lots in Trinidad, located on Underwood Drive. It's about 3 acres. It has a 2-bedroom house and a long driveway and an existing septic system. It's been, and most of the lot, the eastern half of the lot is pretty flat and grassy. It slopes a little bit towards the southwest corner as it gets there. The referrals were sent to various city staff and interested agencies. No substantive comments came back as a result of the referrals. Department of Environmental Health noted that the septic report looks fine and meets their requirements. Just that they would have to apply for a septic permit and development of those lots. Also, the city engineer didn't have any comments as the city engineer, but he does have to recommend approval of lot line adjustments under the city's code. And I think I talked. Oh, and then potential conflicts of interest. So Commissioner Slay owns property that is approximately 400 feet from the nearest property lines. So for a commissioner that's within 500 feet or less, there's a presumed financial conflict of interest. The planning commissioner has the option of either rebutting that presumption of a financial conflict or recusing themselves. In general, if you're going to recuse yourself, it's best practice to. Yes, we'll.
All right, Commissioner Slay is recusing himself and leaving the building.
All right, so then the next section is the subdivision ordinance consistency. So the city does have a subdivision ordinance with adjustments. Under that section, both the city planner and the city engineer have to recommend approval, certify that the map is correct. The city engineer, as a licensed professional engineer, can't actually review and comment on surveys and lot lines. So that has to be done by a professional licensed surveyor, land surveyor. So they did refer the project to a surveyor in their office. I included their comments on here, and then the agent surveyor also submitted a response. So most of those things are going to come up as part of the reporting and the map after the approval, if it's approved. So those comments meeting those requirements have been made a condition of approval. And then the city planner recommends approval with these 5 findings. So the planning commission and the planner, the lot line adjustment does not violate existing codes and policies. The lot line adjustment will not create difficult or unreasonable access to the parcels. The lot line adjustment will not require variances to permit standard development. Utilities and public services can be provided to the revised parcels and no street dedication. And the next section includes a more in-depth analysis of the zoning requirements like setbacks and things like that. The lot line adjustment does show generous building envelopes. New lots will be located adjacent to Underwood. So there's no access services. And so the planning commission can approve the lot line adjustment. Staff recommendation is for approval. There are some limits on the kinds of conditions that the planning commission can put on a lot line adjustment. Obviously for this project, as we've seen from the public comments and actually people in our audience tonight. There's definitely an interest from the neighbors in how this lot line adjustment and its future development might impact the views. And so, this is a lot line adjustment. Lot line adjustment is not subject to design review. I do not recommend putting limits on future development as part of the lot line adjustment. I think that needs to be reviewed on a case-by-case basis. When future development is proposed, some set height limit, it's more than just the height, for example, it's orientation and other things that the planning commission looks at as part of design review. Having said that, one of the findings is that the lot line adjustment does not violate existing codes and policies, and that does include the design review finding. So, I think, if nothing else, for the benefit of, people who might buy these lots in the future and want to develop it, I think it's worth considering whether the lot line adjustment, maybe exacerbates future view issues, design review. Again, I'm not recommending requiring any changes. I think it meets all the requirements. I don't think the lots, doesn't present any difficulties for developing the lots. But I did suggest to the applicant that they consider, maybe there's a discussion, maybe there's some sort of different lot configuration that could satisfy. Cool. So just putting that out there, as I think, the planning commission can have that discussion about the configuration of the lots, but just, pointing out that, currently it's 4 lots. The current development process and property lines, that existing house could be removed and 4 houses built. Resulting configuration is only 3 parcels. So in a sense, it's decreasing density and development potential. The larger lot could potentially be subdivided in the future, but that seems that'd be a significant process to go through something like that. It's not in an area of any hazards or slope stability issues. As I mentioned earlier, a report was prepared, testing and soil testing was done, and recommendations for the design of 3-bedroom septic systems. And those are shown on the lot line adjustment. No changes in landscaping or fencing are proposed. Design review is not required. Staff recommendation is for approval with the conditions, 3 conditions, that the applicant is responsible for paying all the costs, and then meeting the surveyor's comments, and then getting the city engineer certification in writing on documents. Planning commission can add conditions of approval if they feel one or more of the findings can't be made, delay action or continue the hearing to get more information, or deny the project if they feel that some of the findings can't be made even with changes. I don't have to answer questions.
Hey, commissioners, any questions for Trevor?
I'll kick it off. So Trevor, I don't speak surveyor. So on page 3, and if Mr. O'Hearn is here, thank you. I'd like to at least understand what in the middle of page 3, the surveyor provided the following comments. I don't know what a basis of variance statement, or I think I understand boundary and quarter monuments, but I don't understand if they are based on California coordinates. So could we get a little bit of explanation on that, if possible?
I will defer to the page.
If you want to answer that question, that'd be great. Just come to the podium and we can.
Good evening. My name is Mike O'Hearn. I'm a land surveyor with Kelly O'Hearn Associates, and we drew the tentative map for this project. One of the questions was basis of variance. basis of variance basically on a map stating what was used for north. We don't all use true north because many of the old surveyors didn't use true north. So it's just how the survey is related to north on, in this case, on the subdivision, Underwood's subdivision. So it's just how to relate the bearings so that in the future, another surveyor could trace the survey accurately.
Okay, thank you. And now the other question was what it means if they're based on California coordinates. Is that?
So California coordinates, that's a system set up by the federal government. You know, the world isn't flat. And so when we're working in a small area, the difference between working on a curve, but if you're working, say, for Caltrans and surveying 299 from Arcata to Reading, the fact that you're going over the earth makes a difference in the calculations. So California coordinates breaks California into 7 zones, and each of those zones is basically like taking an orange and then making a slice through it that's flat. And so that's what California coordinates are. Boundary surveyors don't normally use that kind of process in a subdivision or a slot line adjustment or a boundary survey. They're more for larger projects. To me, it adds a little bit of complication. It doesn't need to be there, but it is perfectly good tool of use. It's just an option.
Thank you. Appreciate it.
Thank you. Any other questions for Trevor?
Yeah, Trevor, on page 4 of your staff report, back at page 19 at the bottom, that last paragraph, earlier determination of the state attorney general, I guess I wasn't sure why that was included or what, is there some reason behind that or what that's pertinent? Because, I mean, it is pertinent, but.
No, it's just, it was in the staff report. It's been in previous lot line adjustment staff report, so I just left it in there. I'm not sure why it originally got put.
Richard, anything else?
I have one more.
Yeah, please.
So I completely understand what you're saying, Trevor, in terms of specifically tonight, lot line adjustment does not require design review. But I got a little concerned and I have a little question. If you go to the ordinance and that's 1760, and I think it's .4. Sorry, I should have tagged this.
Is that one of the view protection findings?
Yeah, it has to do with the definition of use. The definition, oh, I'm sorry. I should have tagged this.
Are you under the review procedure? Planning Commission shall prescribe application form of information for use.
Yeah. Click on it. There it is.
17.06.
So this says use means the purpose for which either land or water or a structure thereon is designed, arranged, or intended, or for which it is or may be occupied. Wrong one. There's another one. Come back to me. I'm
Okay.
sorry. I
that's fine.
apologize. I gotta find it. Come back to me.
I have a couple. So on page 4, Trevor, you talk about referencing 1624.03, item 3, the recommendation that the lot line adjustment will not require variances to permit standard development. And my question for that relates specifically to parcel 2, where you talk about it does not have required setbacks. So that by definition would be a variance that would be required based off the existing size that they're proposing for lot 2. I wasn't clear how that.
So it's just, they just showed a building envelope, and that
Right.
building envelope is much bigger than what a building would likely be. And so it's a little bit big, so it shows it's 10 feet from the front instead of 20, but it's 10 feet from the sides instead of 5. So it'd be wider and narrower, if that makes sense, but it's still plenty of building envelope to meet required setbacks.
So it does not then.
It would not require a variance.
Okay.
So I just drew the box a little off.
Okay, so that's something we could clarify. I mean, does that building envelope on there, is it meaningful at this stage or no, whenever something would come before us for design review?
You know, if that's drawn, if a building envelope's on the final map that gets recorded, I'm not sure building on it, they don't go on the final.
That
map.
wouldn't be answer, it would just be the broad lot lines. Okay. That's more just for demonstration purposes. Okay. That was my question for that one. Then. Okay, that answers my other question, which was by doing that, did we increase the degree of nonconformity on the process, on the parcel? Because I was thinking back to the lot line adjustments we did for the lake parcel, or not lake, but yeah, Bob's, right? Katie's Smokehouse. That is all I think I have right now. Tom, did you have anything? at this
Yeah,
point?
so the lot line would just be the outside line, the building site would be, could be the first one, moved away from, I mean, the house could be designed. That's not going to be on the town.
That's correct, yeah. So, you know, there might be some limitations on where they design the septic, and if they want to put the house outside that envelope, then maybe they would have to do some more soils testing, because that's where the septic testing was done, so that's part of the reason for drawing.
But down that hill would make it better from the view.
Essentially.
I had one more that just popped in, sorry, because I have a similar lot in town that is made up of several smaller parcels under one APN. How, is it just commonplace practice to have a structure built across existing lot lines? Is it based just off the APN, or is it just was an oversight back in the 50s?
That house was built, yeah, like maybe at least the early 50s, it shows up, I think, on the 54 aerial photo.
Yeah.
And that was right after that subdivision. So, you know, it just wasn't something that there's a lot of multiple, like in Trinidad, it was originally like 25-foot lots. And so they're usually multiples of 25. People often bought multiple lots depending on how much they wanted. So back then it wasn't uncommon. Today, you know, like for the septic system, you need to be able to build a septic.
Anything else from the commissioners? Richard, you still working on that?
Well, maybe I'll just rephrase it this way. I just want to make sure that in the definition of use, which I think we normally understand, that a lot line adjustment is not considered a use.
No, it's not. I mean, it's not a change of use. It's not, I mean, in most places, it's not even really development. Under the Coastal Act, it happens to be, they consider it development, a change in lot lines. It's a need for a public hearing. No, you know, it's zoned residential, it'll stay residential. And it'll remain vacant.
So then just again, this is more for clarification. If I look at the map and I look at the current 4 lots, it is conceivable that lot 12 right now could be sold.
That's correct.
Okay. And lot 9 could also be sold, assuming that the existing leach field for lot 10 is changed.
That's correct.
Okay. So there's that risk regardless of whether or not there's a lot line adjustment.
You could also argue that lot 9 could be sold right now. The existing leach field could just be written in easement across lot 9. They wouldn't even have to move the leach field. So, yeah.
Yeah, probably, yeah.
Potentially exists, okay. Any other questions of Trevor right now? And I apologize, I didn't say it earlier, just procedurally, what will happen next is if the applicant's present, they'll make a presentation, then we'll open it up for public comment, and then we'll bring it back to the commissioners, just so you guys know where you fit in tonight. With that, is the applicant present and wanting to make any kind of a presentation to the commission or the public tonight? Sure. Welcome back.
Thank you. I'm here on behalf of the applicant. So when the applicant started this project, they came to me with their map, and I looked at the subdivision map from 1948 and saw that 27 lots were approved in 1948. Most of the lots have been built on, some not, but the applicant owned 4 lots. So we worked on trying to come up with a design for 4 lots to move the existing lots around and create 4 lots, one for the existing house and 3, you might say, new lots or reconfigured lots. So the city had a concern that the lots might not be suitable for development because they might not have septic tank suitability. So a geologist was hired to design leach fields, and she did substantial testing on the property. And she came up with a recommendation for 3 parcels, the existing house and then 2 resulting vacant parcels. And so she had the leach field as shown on the map that I prepared. That's not to say that the leach fields have to go there. It's just that this demonstrates to the city that there is a place where a leach field and reserve field can exist on each parcel. And so then the other area between the leach fields or in front of the leach field is shown as a potential building envelope. There's no commitment to build any particular place within that envelope. And it was discussed that envelope could be moved if the leach field testing was done in a different place. So as we've talked about before, this is a lot line adjustment. It's not a development to build houses. Surely houses will be developed in the future. But that's not the purpose of a lot line adjustment. It's to create the reconfigured parcels. And the new houses would have to go through design review, would have to be sure that they fit within the area designated between the leach field areas. And then they have to actually get a septic tank and leach field permit from the county. They could do, as discussed, they could do more testing and move them around. So I think that the best solution for people that are concerned about where the building is going to be placed is to work with the owner that's going to build a building, either negotiate, buy a view easement. There's many options, but we really can't settle that tonight because there is no building permit in place. We don't know how big the house is going to be. We don't know what kind of roof it's going to be, 2-story, 1-story. So it's just premature to try to second guess all possibilities. So I don't really have anything more to say than what the planner said. I think she did a great job of summarizing this project, and you can answer any questions that you might have.
Okay, questions from the commissioners for the applicant? All right, thank you.
Thank you.
At this point, we will open it up to public comment. You get roughly 3 minutes. Please feel free to come to the podium, introduce your name, try and speak into the microphone so everybody can hear. Responses from the commission will be limited. We're just looking to get input and hear everybody's perspective tonight. So now the meeting's open for public comment. Please.
Hello, my name's Gary Wagner, and I understand I live at 826 Underwood with my wife Susan, and we've owned our home there for 10 years. I do live across the street from this property. So I do understand the issue tonight does not involve future building on this lot and or either of these lots. But I thought it was important in order to have on record that I was concerned about future building and how it would affect my view from our house looking out at the ocean. I feel that the view that we currently have is excellent. We bought this house 10 years ago because of its central Trinidad location and because of its view. You know, I probably never considered at that time that anybody would be that there would be any lot adjustment or anybody building on this property at any time in the future. It had been that way for 70 years, and I had no thoughts that it would ever change. But, you know, I felt like if it was going to change, I wanted to at least voice my concern, and I appreciate you letting me speak regarding this issue. And my wife and I would be very upset to think that some house would be built on one of these lots that would be in future blocking our view. I did submit 3 photos, which I believe are included in the information on this project. One of them does show our current view. The second one I've taken and imposed a potential 1-story house on this property. And once again, I feel that the view would still be retained. And the third photo I included would be a potential 2-story house on this property. And I felt like our view would be significantly affected in wherever that house was built. If that's all that I want to say regarding that, I would hope that that our comments will go on record, and that at some time in the future that when we come back here again in order to discuss the building of these houses, that we will at least have reference to this and or thoughts regarding what was going to be built and how it will be designed. Thank you very much.
Any other members of the public?
Hi, my name is Bev. I live at 898 Underwood, also directly across from the proposed project. And thanks for the explanation of what we're doing here tonight about land adjustment. So my comments are very similar to Gary's. We understand that this is going to happen regardless. This lot line adjustment and potential buildings going forward. Our houses would directly affect our view to Pivotal Island, the head, the Flatiron. When we bought the house a few years ago during COVID, one of the selling points the realtor told me is, "Hey, this place will never be developed across the street." And I was like, "Oh my God, this is beautiful." I'm all for the project going forward. I just want it to be done in a way that is respectful of the neighbors and we're on record.
Thank you. Anybody else in the room tonight?
Hi, my name is Jillian Hassenfritz. I'm actually the trustee of this property. So I am effectively the responsible party in this conversation. And I just want to say a couple of things. One thing that might be of interest to know is that this property is actually on a trust. And the trust property, how the trust is to be distributed has already been determined. So what we're doing right now is, as Micah Hearn has said, our family has been in possession of this property since the 60s. And it's been unchanged. And because of our relationship in the community of Trinidad, this was our attempt to create a much more workable environment, because as has been stated before, if we turn this directly over to as it is now, it's very much a potential that the people who are the entity that is receiving it would just sell off the lots, and there would be a lot less of an ability to make some of the adjustments once the actual building part comes to fruition, because there wouldn't be as much of a space to work within, because the lots would be as they are now. So they could very easily just sell off the lots. Those could be building permits could be applied for, and there would be much less of an opportunity to have a public comment, to be able to do some of the workings like we're talking about, where we're moving it a little bit further down the hill or doing different things like that, there's a potential that that would no longer become would no longer be feasible if it just gets turned over and those properties get sold as they are. So just to give you a little bit more forethought in why this was even brought to the table to begin with, was in an effort to be able to work with the community that we have been, you know, somewhat involved in for generations.
What was your name again? I'm sorry.
Jolene Hassenfritz.
Hassenfurt?
Fritz.
Fritz, thank you.
HASSENFRITZ.
Are you open to being respectful of the neighbors and putting it into potential sales for the future? Are you open to talking as we concerned?
Yeah, I mean, at this point, we're open to anything. We have certain, you know, I have certain obligations to the beneficiary, obviously, that I have to meet, but in my personal view, those parameters could easily be met.
Great.
Are you able to just answer, is there intent to put the 2 parcels up for sale, or is that not something you're able to speak to right now?
That's the plan, is to put them up to sale to be able to make up some other values. I have to be able to turn over the value,
Sure.
and that's what we're at.
Okay, thank you. Any other members of the public in the room with us tonight? All right, anybody online? Any public comments? Seeing none, we will bring it back to the commission unless, Mr. Hurd, you have anything else you'd like to add in response? No? Okay, back to the commission for additional discussion. Entertaining of a motion.
I'll make just a couple of comments. First of all, I deal with a view easement myself, so I know exactly what some of the concerns that some of you are sharing. But you know, I kind of look at this in the sense that this is, as I pointed out earlier, several of these parcels could be sold right now, and no lot line adjustment we would not even be discussing this. And that risk has been there since, I guess, 1948. However, I really feel that the Planning Commission's past, and I'm certainly in the future, have been very sympathetic to parcel owners regarding easement view protection. And I think that's evidenced by some of the things that we've done just recently on Underwood, just down the street from most of you. And another prime example is right there on Hector, where initially that was as I refresh my memory, but that was a 2-story house.
Both on the corner of Hector and Edwards and Hector and Trinity, both those
Yes.
were originally 2-story.
Right. So we were able to work with everyone to reduce the size of those structures to help protect views for the neighbors. So I'm pretty confident that in the future we'll be able to look at this with a certain degree of trying to accommodate all of the local neighbors. And so I feel pretty confident that I can approve this tonight with the intent that it'll come back to us certainly in the future, and we'll have lively discussions at that point.
And I like that.
I'm done. Thanks.
I like that you're open to discussion. So you said you could, put it in the writing. And that saves a lot of work here. Or hopefully reassurance for what you're getting. Thank you for being open to doing that. And yeah, so, great. sad to see it go, but
Yeah, I second what Richard was saying. I mean, obviously, I'm definitely sympathetic to everyone who has the views across that lovely empty lot. And I mean, I guess obviously when you buy a house next door to or across the street from an empty lot, that comes with some amount of risk. I have an empty lot. Well, that, you know, your neighbor might propose a project there. But I think, as Richard noted, that the commission has a pretty strong track record of protecting views in the city. And I think should whoever the applicant might be in the future that proposes a building project on the lots, I mean, I think they hopefully when they come to us, we'll have taken that into account, because probably not going to get a lot of traction hypothetically here, but so I'm comfortable with the project as is. I guess my only maybe nit to pick is on the conditions of approval. Condition 2 that has this basis of bearing statement, et cetera. I guess my thought on that is, I don't know that that's really our purview to ask for those things. I think that's something that the county surveyor, map checker will ensure is on the map when it gets filed. And I don't know that it hurts for us to ask for that, but I guess going back to that statement that you included, Trevor, on page 4, it does say that the advisory agency or local agency shall not impose conditions or exactions on its approval of lot line adjustment except to conform to local zoning, building ordinances, requirement for repayment of taxes, for the lot line adjustment, or to facilitate the relocation of existing utilities, infrastructures, and easements. And I guess like those things aren't really in our jurisdiction or purview. And I guess on top of it, I just feel like, I mean, Mike can probably speak to this, but he's not going to file a map.
I think you're right. I think whether you include that condition or not, the city engineer is not going to certify the map without those things. So it was really more of a kind of a heads up to the reminder that needs to be done. But I don't think it's necessary, because Josh isn't going to certify that until that's done.
I mean, I would suggest that we remove it. I don't know. I mean, I guess I can ask Mike, is there any chance that you would file a recorded map without putting any of that on there?
No, I don't think it's something that planning commission should be involved in, because you wouldn't have the expertise to check it at the end anyway. So I think you should rely on the county surveyor and the city engineer to do their normal job.
Just on that same thread, Trevor, I'm looking back to the minutes from March of 21. Anyway, the lake property, the adjustment there, and I'm seeing, I think maybe how this was captured there. Recommendations of the city engineer shall be required to be met prior to certification of the lot line adjustment map, and then responsibility goes to the city engineer. That's a more generic way to capture, just to make sure it happens, but keeps us from getting into the details, which I agree we don't have the expertise or the need to get ourselves in. I don't know, would that replacing it with that one, or?
Sure. Yeah.
Yeah. Says recommendations of the city engineer shall be required to be met prior to certification of the lot line adjustment map, and then responsibility city engineer prior to map reclamation.
Okay, we've got the second part here already, so it's just the first part.
Yeah, it would just be kind of the straight, the non-italicized text. Yeah. Any concerns with following past precedent, Trevor?
Yeah, I think the one difference between the two is that we have the comments up front. I think for the lake, we didn't have that detailed review yet. And so it was just sort of, we had to use the blanket statement. So I think that's the only difference. I think, recommendations or requirements of the city engineer have to be met. That's fine. It's fine. Captures it, because it's just that the city engineer has to sign off on it before it's, that's all.
So that's what we're going with.
I guess what we want, we'll just eliminate the second condition and then I want to say the third condition covers it, or do we want to add something that? Let's see.
Would there be any other,
I mean, he's not going to certify it if his recommendations are.
and there's no other recommendations that would come from the city engineer that he didn't already make, right? Because he had a chance to review.
It does say, well, upon surveyor recommend.
I guess I just don't want to paint us into a corner where if something else pops onto his radar, when he looks at it again or gets the final version, he's like, hang on, there's something else. And then, well, wait a minute, you were overly specific here in your requirements and your conditions instead of being general, allow him the room to do his job.
Yeah, I mean, I think as it's written is fine too, upon surveyor review and approval. So GHD surveyor has to review and approve the map, and then the city engineer shall certify the lot line adjustment. Maybe you want to change shall in case he has any additional requirement. No, I don't think so. I mean, Josh already had a chance to the city engineer had a chance to comment on the lot line adjustment and had no comment. So it's really just the surveyor. So I think it's fine as written. Either way.
It's a pleasure of the.
Well, that's what I'm trying to figure out. Are we saying that we're deleting 2 altogether?
I guess I'm comfortable. I prefer putting in the more general recommendation, city engineer shall be required to be met, and having something like that in there, just because I think it gives some more overall coverage rather than deleting it. But I don't know, maybe that isn't the best practice. It was just happened to be in the lake property. I guess I'm envisioning this map goes back to the surveyor, comes back, and something's different and comes to Josh's attention. I want to make sure there's enough room in the condition for him to.
Sure.
But if I'm worried about something that doesn't seem reasonable, that's fine too.
No, that's fine. I just want to make sure that we weren't.
Okay.
There's still a 2.
There's still a 2.
Okay.
Right?
Yeah. I think we want to make sure that the city engineer signs.
Yeah, with that language that I read into the record from, okay. All right. Anything else? Any other discussion? Okay, then I guess just for clarity, I'll go ahead and make the motion. I can find that here, Trevor. So based on the application materials, information, findings included in the staff report, and based on public testimony, I move to adopt the information, required findings in the staff report, and approve the lot line adjustment as submitted and as conditioned below, with the change to item 2 to eliminate the first section there and replace it with recommendations of the city engineer shall be required to be met prior to certification of the lot line adjustment map.
Second.
All right, all those in favor? Aye. Okay, passes unanimously 4 with 1 recusal. Thanks, extension. I was just not here. All right, thanks, everybody. Appreciate your presence tonight.
You don't have to leave.
Yeah, you're welcome to stay for the rest of the incredibly riveting commission business tonight. I'm going to let Commissioner Slay know that we're back in session. We'll just take a brief 5 to 10 minute recess while you rejoin.
Hi. Well, thank you.
Recognize.
Yeah.
think if we can work it out, so by the time it comes back, it's set. Everybody takes a picture of them.
Anton, are we muted in the room, please? Online, thank you. Okay, we will now reconvene the meeting and proceed with the next agenda item, which is Trinidad 2023-03, update on the closure of the ALMT and progress to date to reopen the trail.
Sure. So just as a reminder, back in April, the Planning Commission approved the emergency closure of the Axel and River Memorial Trail and Parker Creek Trail to protect sensitive areas and public safety due to the erosion over the winter. The Planning Commission conditioned that approval on monthly staff providing monthly reports. The Parker Creek Trail has since been reopened. The Axel and River Memorial Trail, the temporary closure was extended, although the Planning Commission made it clear that they want to see some progress on planning for a temporary repair while the reroute is being planned, so that it can be open by Memorial Weekend. So staff has heard that. The city manager requested GHD to come up with some recommendations for some, as minor as possible temporary short-term kind of repair options for the base of the trail in order to get it reopened. The city planned on then taking that to the management team, the Ancestral Society, to work on, seeing if they were amenable to that and seeing if we could come up with something. Again, while the reroute is being planned, since that's going to take time. And then the city received the attached cease and desist letter, and then city's attorney responded to that. And so and that's very recent. And so we didn't, we don't really understand what it all means for sure. Paul is here tonight, the Social Society's attorney. I think he can provide some clarification. He provided me some good information actually just after the last item. The attorneys are still meeting. The management team meetings can continue. We were worried that we wouldn't be able to meet with them. So yeah, like I said, this is kind of new developing. It sounds like there was some misunderstanding maybe on both sides in terms of what the letters meant, what tonight's meeting was about. As you know, no actions being taken tonight, just providing this update. And we will continue to reach out to the Ancestral Society to see if they can come up with some short.
Okay, any commissioner questions for Trevor based off the staff report? The update.
Is there any way, reading about, well, not really reading very much, but hearing about this ongoing litigation between the city and DIS, I guess, can we get a synopsis that's all about what that's about? Or is there nothing?
I don't even know really. I haven't really been involved in it over the years. I don't know what's confidential. Maybe Paul's willing to provide a synopsis, but yeah, I can't. The council gets those updates in closed session.
Any other questions or?
Just, I think we asked about this last month, and I'm just curious if we have any information on whether the Ancestral Society has been successful, or are they still working on a grant, or do we have any information on the status of that funding source, perhaps?
Well, so their grants. Well, the grant was for the feasibility study that they had. And GHD did provide that study. We do not have a copy of it yet. So that grant might be done. And then the next step would be to look at the repair recommendations in that report and go seek some additional money. But I don't know what that report looks like. And I'm guessing they haven't had a chance to apply for funding.
To clarify, the city still does not have a copy of the report from TAS. Okay. All right. Any other questions from any commissioners? If not,
I've got hopefully a quick question. Have we had any conversations with Steve Allen about the information here, these 6 recommendations, or are you sort of taking it at face value? Some questions about, the extent to which erosion is happening, right? It seems like not doubting this at all, but it seems based on this information, that there's potential for a lot of erosion really quickly. And that's why keeping the trail closed over the winter, right? And kind of wants the trail.
Oh, well, I think, that's just, during the wet season, more foot traffic, more rain, wet, cause more erosion. And then, winter storms, we had, there's another big storm event, that might have some additional erosion. So the recommendation is to leave it as is through the winter and not any more soil disturbance or anything like that until the dry season.
Right, and I guess my biggest question is sort of related to that. That's regarding what's happening at the toe of the bluff, where there need to be some descent from the trail down towards the beach. And I'm wondering, is that situation really so dynamic due to so much wave action and erosion? It's not really feasible at this point to plan how that might happen.
I think that's a good point. I'm not sure, again, this was just sort of put together as a starting point for discussions. It's not actually a proposal. And so, I think that the idea was, it's pretty vertical down there. The city should explore putting some material, that might be not be feasible. And it also might not be worth the expense if the trail is just rerouted anyway. I do know there are some trails where they put in ladders every summer. Basically cable steps, and so it's still a use at your own risk and a nice vertical ladder, but at least it would be accessible. So, that to me, that was the one where, I don't know.
Yeah, we've heard some public input in the past about ways that you can descend it down that final ditch of the bottom without having to disturb much. There's a lot in here about these wooden cable steps or something of that sort. And I just think that if it's not really truly too early, it would be nice to consider some ways to minimize disturbances down there to other things.
Yeah.
If dying to do any digging or adding any material. So it's possible to start thinking about creative solutions that wouldn't disturb things. But now is the time where we really truly have to wait until after all the wave action from the winter is behind us.
Any other questions, comments from the commission? Open it up for public comment.
Good evening. My name is Paul Gaggers. I'm here on behalf of Surrey Central Society. I prepared some letters. I only have 3 copies.
Copies.
Just to do this, thank you for allowing me to speak.
Anton, are these speakers working?
Microphone.
Or so just
You haven't heard much from me?
There we go.
Better?
Yeah.
okay.
I'm notoriously soft-spoken. It's late in the day. I've had a very long day and I have a headache. So I apologize if I speak and you don't hear me, or if I'm not speaking clearly, please. I can answer any questions you have, I believe, or at least I can try to explain some of these things. I would submit to you that we do take issue with some of the representations that are presented in this report. It's not my opinion that anyone is misrepresenting things intentionally or anything in that regard. Just as Trevor indicated, there are often misunderstandings in communication. I provided with my letter copies of all the emails that I'm aware of that have gone back and forth between our clients, the Shuri and Social Society, the city management, so that you will know that there has been a communication, that there is no attempt to cease communication, that the management team, which is put in place to address issues on that study area, they have met on these issues. Our clients did not ask that those meetings be canceled as is represented. it was assumed that my letter, which is not related to the management team meetings, was a request to cancel the management team meetings without any request or for clarification from me. I do speak with Russ Gans, the city attorney, with some frequency on this matter because of the litigation. When I sent the letter, we spoke about it. He sent the letter back to me. If you look at the letters that are attached, you can see that there is no request for an indefinite cease and desist. It is not a request for an indefinite stop as is represented in Mr. Gans' letter. There is litigation with a trial that was recently, that has been set, was recently continued to September. There is an end date on this litigation, as there is in all litigation. The parties are working to resolve these issues informally if it can be done. There have been many potential resolutions, they just have not resolved this. So the question that I heard was, can you give me a summary of what this litigation is all about? I can do that. It may be somewhat one-sided. I'm an advocate of it. And I'm also a person, which means I look at things through my two sets of eyes or my set of eyes and not everyone else's. So having said that, years ago, there was litigation that is referred to as the frame litigation, but it was brought by the Churi Ancestral Society. I suggest to you that the slope, the TSA, slope on the side of your city is one of the most hallowed places on earth for the people of the Churi Ancestral Society. Their ancestors are buried there. It's the remaining area of land that was once the home of their people. So it has all sorts of meanings to all sorts of people. A lot of people think of the view, they move here, it's a beautiful city. But the people of the Churi Ancestral Society, that's the most hallowed place on it. Their DNA is in that circle. They filed litigation against the city because it was there, because of, I don't want to get too much into it, their belief that the city was not adequately taking care of that problem. They filed that litigation to open the trail that is the subject of tonight's meeting. They do not want that trail. So they have always wanted that trail open. We asked that it be temporarily closed to address the erosion issues and to address the issues with people going onto the site from the trail and accessing or compromising the cultural heritage of this area and resources that are there, such as middens, burial plots. There's a lot of history. You and I aren't part of because we haven't been here that long. The frame litigation was settled. I don't have the years right now. I apologize. I didn't come here prepared to discuss that. With an agreement to, we understood, my clients understood at the time, for the city to transfer that property to the Yurok tribe, or the Yurok tribe and the Churi Ancestral Society. They were to participate in the management plan. So pending that transfer, the property would be taken care of with all the parties that should be involved in the discussion. It was the Yurok tribe. This was all Yurok tribal land. The people from the Churi Ancestral Society, which are the descendants of the people that lived in the village. The neighboring community, and of course the city, the state of California, Coastal Commission, and they were all part of it. This was signed The Surrey management, the management plan was put into effect. And the Trinidad Rancheria, because they live nearby, were given the opportunity to participate. And they chose not to. Everything was continuing, progressing along towards the management plan, what 3 people meant was going along towards transfer of the property to the Yurok tribe. And then the Rancheria at some point wrote a letter to the city saying, no, we don't want this to happen. And these are all the reasons why. And I don't want to get too much into the issues associated with that. But the Rancheria progressively has claimed that they have an interest in the Churay and the village because they have ancestors that are from that village. The city filed a request for declaratory relief, and that is basically filing litigation with the court saying, look, these 2 people, or 3 entities, the Yurok tribe, Churay Ancestral Society, and now the Trinidad Rancheria, all claim an interest in this. And we are in the middle, and everyone knows when there's a fight between 2 elephants or anything that really gets damaged is the grass, and we feel like we're the grass, so we want you guys to settle this. We need a court to say who settled, who has what rights to this property. We filed a response, we filed a cross complaint saying, hey, look, city, during this time period, you're not doing your job, or a very good job, in our opinion, of maintaining the property, because it's gone to not being maintained. I'll leave it at that. The Trinidad Rancheria filed a cross complaint too against the city and the Churay Ancestral Society. There has been discovery. We have requested any sort of discovery to establish that anyone from Trinidad Rancheria lived in the village. We do not have such evidence. It is our belief that there was no one that was none of the original assignees of the Trinidad Rancheria. And had I thought about it, I would have been able to come here and provide all this evidence to you. Were their ancestors residing in the Churay village? Anecdotally, I understand. This is anecdotal. We have not been provided in discovery of this, but anecdotally, we understand that there is a claim that one of the original assignees, mother or grandmother, was born in the village. We have evidence that would dispute that, but I don't want to get into litigation too much. But at the end of the day, that's what the litigation is about. It's, at least that's my understanding. The city owns that property. It is an obligation that they have to maintain it. There is a dispute as to who has claims to it. No dispute as to the Europe. No dispute as to the Church Ancestral Society. There is a dispute as to the Rancheria, but the city, I don't want to, I'm not speaking for the city, but the city, frankly, doesn't want to make a wrong decision as it relates to the Rancheria. Because after all, if they are from their wife, that's not the city's issue. So until this is resolved, we have said, hey, all things that impact the deed or what's going on in that city, we want it to stop, not from the management plan, because that's the process that it's in there, but unilateral decisions outside the management plan. There have been discussions, and Russ can, Mr. Gans can dispute this, but there have been discussions about the transfer of that property, that the city has the right to transfer that property. There was a point in time discussions that the city was just going to quitclaim it to 3 entities, the Europe, the Rancheria, and the Church. to hash out. So there's always been this fear that the city will take unilateral actions related to that property. And that's what the purpose behind the cease and desist letter is. It was not intended to stop anything through the shoreline management team. That's always been the process, and that was up until it was canceled by the city, representing that my clients have requested cancellation, and it was their interpretation of my cease and desist letter. So that's a nutshell of the litigation, I hope. We are scheduled for trial in September. I hope an explanation as to what got us here. Representation that there's lack of communication. I'm an attorney. I don't expect anyone to believe me. That's why I like evidence. That's why I attach the emails. So you can see these communications. If there are things that are missing, that's not because I have intentionally omitted it, because I've been finding and going through things in a hurry. I am happy to come again if there are questions my client authorized for us. I find that in the absence of information, humans tend to fill those gaps. Their own information, fear or speculation. This is something that you need to know about. I think communication is, to me, is key in a relationship. The Churai Ancestral Society is in a relationship with the city. They understand further relationship with the management team. They would like that property to be returned. They would like it to be returned to the Bureau of Tribe. They believed that was the intention of it. That was their intention, Frank said it. They believed that that was the intention of the city, at least for a period of time. They are reluctant to take that property as a nonprofit for fear of the financial repercussions that they may experience if the rancheria is in litigation with them endlessly over these issues. That's what we're hoping to resolve in September going forward. But there is no attempt to indefinitely stop progress in any way of study area. I can assure you of that, and I hope that this letter and the contents of the emails can confirm that for you. And I would tell you that the new date that was set for September is past the 5-year statute. So in the law, if you file the litigation, that matter has to be tried within 5 years from the date you file it, or it gets dismissed. The date that we just continued was set just before that 5-year time period runs. If this case is not brought to trial in September, unless the parties agree to continue it, it gets dismissed. It is over. People can refile it, but it is over. There is no endless or indefinite in this process. There are very real evidence. Will the trail be open for Memorial Day? I don't know the answer to that. Our clients are working to get a grant. They're working to put a project together, a proposal, together. And the process, as we understand it, and that we anticipate proceeding in, and that's in the letter, is when that is completed, it will go to the management team. The management team will review it. They'll make suggestions. They'll make requested modifications. And when that is finally approved by the management team, then it will come before you, but not the other way, because that's the process that was put in place by the city's agreement with the Fram litigation and through the management plan. And so long as the city intends to maintain that management plan and it stays in status quo, we're fine with operating. We just don't want unilateral modifications such as unilaterally terminating the management plan, which has been an issue that's been raised.
Just for, in the interest of time, I appreciate the perspective you're giving us. Traditionally, it's 3 minutes, but we wanted a little bit of leeway here, and the issues of terminating the plan, that's not a planning commission decision, so that's not germane to what we can do here. But I definitely, speaking for myself, I truly appreciate the background that you gave us tonight on litigation that got us here. And that's very helpful for me to have as context.
I understand.
So I appreciate that. Were there any other questions? Or just comments, I guess, right now, because this is just public comment right now. So our responses are limited, but I do want to take the opportunity to open it up to public because we do have some members of the public also present in addition to yourself. But thank you very much. I appreciate it.
Thank you for the leeway.
No problem. Thank you. So are there any members of the public on the screen? I see we have Ms. Provolt and then an iPhone present that have any comments on this update. Pushers. I'm not seeing any. Bring it back to the commissioners. Any other questions, or are we good with the update as received?
I had one question.
Yeah, please.
Mr. Gallegos, from your perspective, I have seen the management plan. It's real. But I guess what is a little confusing to me is when we talk about the management plan, do you believe that that's currently the guidebook that the city and other members of the management team are using to address any of the issues and conditions of the study area?
Yes,
Okay.
I do.
Okay.
I think that it's a group of people. So from my perspective, things don't get decided as efficiently as they might be through another system. But that is the format that everyone uses. My experience is everyone gets together, they discuss things, they try to make a decision, and then based on that group decision, there is an action plan and people move forward. If that's the question.
Yeah, and just one clarification. It was my understanding that the Coastal Commission was not a member of the management team, but the Coastal Conservancy was the member. Am I confused?
Yeah, that's correct. I think when he referenced the Coastal Commission, that was the frame settlement. So the Coastal
I see.
Commission was a party to the frame settlement.
Thank you.
It's the Coastal Conservancy that's a member of management.
Management team. Okay, thank you. Appreciate it. Thank you.
Absolutely, thank you.
All right. Anything else?
Can I
Absolutely.
I put this delicately, but I mean, there's interest among this committee to ensure that there's coastal access via the Lindgren Trail. And I think as part of that interest, we've been anxious to see the report that the TAS has received from GHD. And while it seems that all those parties involved are not quite prepared to share the contents of that report with us quite yet, I was curious whether you might be authorized to speak about a timeline.
It's not that I'm not authorized, I don't have one, but I can tell you before, on the way here, I was speaking with my clients about that. And the very thing that I represent to you about people filling absence of information with information of their own creation, that we need to make sure that as part of this team, that we give people projected deadlines or projected time periods, because that's what is hurting us right now. It's this lack of information to the parties understanding what's going on. So I don't have that information, but it is incumbent upon us to inform our partners on that management team on what's going on, give them projections or projected deadlines. So that will be forthcoming. I just don't have that information. I apologize. And, you know, I want to be mindful of your time and say, but our clients are the ones that wanted that trail open. We do want the trail open. The Conservancy, we always understand that people have access to the beach. There is a trail that gives them. It's not as convenient. there's a balancing of interest, and what we're trying to do is find a way to balance those interests. And I would, without, trying to give a preview to something in the future, the intention of our clients is for that trail to be open for people to access. And I think frankly, maybe I should just stop there, but certainly coastal access.
I mean, I just, from the moment that we authorize a temporary closure, one of my biggest concerns has been, much as you've said, that when people lack information, they fill in the information. When people lack coastal access, they create their own coastal access.
Yes, they do.
And so from day one, I've been very concerned about ecological, environmental, and cultural resources along that trail. And I know the longer that the trail is officially closed, the longer there's going to be attempts to go around that official closure. And for that and many other reasons, I think we're all very sensitive to rapidly we'd like some sort of resolution.
I think that's fair. I will certainly bring that back to my clients, and I'm making a commitment to working to share that information with the team as promptly as possible, so that you will have access to it either directly or indirectly.
And I'll also add, not necessarily speaking on behalf of the committee, but speaking on behalf of myself, that I had interest in receiving these monthly reports because we view that as a vehicle to foster collaboration and get the interested parties together. Kind of regretful that it seems to have been the opposite in this instance. We just everybody in town wants to ensure that trail is doing what that trail was intended to do.
Sometimes trying to be the worst people. So the litigation sometimes complicates things. Obviously, it could be that my letter is what created the maelstrom. That's why I'm here to say we're part of that team. My clients are part of that team. They're committed to that team. They are, without going too far astray, they don't want unilateral adjustments. If we can maintain status quo until there is a determination and people keep working as they have been, we're happy. It's the fear, just as other people have filled stuff, we filled stuff, with that fear of these unilateral moves that require us to go to court, and we don't want to do that.
I think to that end, I just, for the record, want to clarify that this proposal that is in here was just sort of a starting point from GHD that the city intended to take to the management team prior to bringing anything. That was the intent.
We were to take no action tonight anyway. Right.
This was just information. Yeah, we asked for this information just to be brought back to us, just to share with your client, because, not only do we have just this trail closure, but we have the other trail closures in our constellation that we're making our decisions based off, right? And, there's, and my concern is, serial trail closures that end up being this long-term, de facto trail closure. And again, that was the intent. These updates were to just provide encouragement. Hey, we want information, and our mechanism to get that information to the management team is through the city manager. So hopefully that's coming through. If not, that would be great feedback, and we can adjust, the pathway coming through. But we're just wanting information as much as we can have, because we are going to have this temporary closure back before us. And we would love to have an idea for what the GHD report is prior to that.
I understand, and I didn't know, but I do understand, and I accept that completely, and I'm very happy to hear that, and I will do my best to work better communication so that when these come forward, that you hear from us to the extent that you need to hear from us, or I think that's great news, and I appreciate your.
And I also
made that back.
Appreciate your willingness to come back, and speaking for myself, if something comes up, I might request that you come back and speak on what you can come back, because there's been very beneficial for me. And I think the rest of the commissioners just to get some more context and perspective on this.
Absolutely.
Hugely beneficial. So. Right. We move on to our next agenda item.
Thank you, and I'm gonna pick off.
Understandable. Thank you. All right, agenda item number 3, policies for after the fact planning permits. Trevor. Need a moment to jot and say, please
No,
take your.
no, that was great. All right, so after the fact, planning permit policy. So this is continued from the November meeting. The planning commission, you know, we've struggled now and again with after the fact planning process them. The idea of this policy was kind of to try and give everybody an even playing field so we know what everybody knows what's going to happen. We talked about making some modifications to the policy. So the underlines are things that we added in October meeting. And then we talked a little bit more at the November meeting. One of the things we talked about was, you know, whether plans should be professionally stamped, whether a building permit should come in at the same time as a planning permit for work that's already completed. And the planning commission requested some feedback from the building inspector. So I did have a chance to send this to Dan and speak with him a little bit. And he clarified the process, where basically the building code itself doesn't really dictate how to process after the fact building permits. It just says any work will conform to the building code. So it's kind of up to the city. The building official has some leeway to figure out how that's going to happen. You know, I thought the double permit fee was in the building code because that was pretty standard, but I guess that's city. It varies. I believe I've seen it in the city code somewhere. He a couple of things that he mentioned that are pertinent to our discussion was that there are various ways to determine whether things meet the code, and you know, something like the deck that was done, you know, wouldn't require a professional stamp necessarily to prove that it met the building code. There's other ways to do that. One way might be to get someone to stamp it that, yes, they saw it get built, or they, you know, put up the footings and saw what it looked like. Other things, if the applicant has photos, for example, and I have seen, you know, looking at city processes where, you know, and I think we talked about it a little bit last time, could be required to dig up a foundation or pull out drywalls to expose wiring. So, yeah, a stamp, I mean, I guess, you know, maybe it's a deterrent if someone has to get that, but I think it maybe complicates the process where it doesn't need to be. So he didn't recommend that, you know, that be the case for planning permits. And then also he pointed out that he really can't review building permits until the planning approval. So you can't issue it, you can't comment on it, you can't take fees until the plan, because it's not approved. So he really can't take a building permit application till planning approval. You could require that they just submit an application with the planning application. But nothing can really be issued or officially done on building until. So those were his comments. And that's the information I have for you tonight. You know, it's a complicated process. You know, I do think that the city has the code enforcement mechanisms that it needs. You know, this process is sort of an in-between the code enforcement to, okay, well, here's your chance to get into compliance before we use those hammers. And one other thing that Dan mentioned is he's seen instances where jurisdictions or notice of, violation. So if someone doesn't comply, because code enforcement is difficult and it's expensive, and so, maybe the city might choose to, instead of going down that road, if someone's not cooperating, just report a notice of violation on their property so that future owners, future lenders affect things in the future. So I'm not sure that's something we want to tackle now, but maybe in the future might be a tool to add to the city's nuisance abatement code enforcement ordinances.
Questions for Trevor? I would say thank you for getting Dan's input. That kind of really closes the loop on that. He feels like he has the tools to super comfortable. Personally, so. Any other comments from the commissioners, or we're open to public comment? All right, we'll open it to public comment. There's nobody in the room. Anybody online joining us virtually? Any public comment on the after the fact permit processing? Not seeing any hands or unmuting going on up there. I'll bring it back to us. So as it sits before us, Trevor, there are no changes to the existing policy, correct?
So the existing policy as adopted,
February of 21, it says.
February 21. So this one here for updated November. So I haven't updated it since November, but this is updated from that officially adopted policy from 2021. The underlines are the additions. And so you have not officially adopted this. So if you like this, I would recommend that you take action to.
Thank you. Okay. So what is the pleasure of the commission? The underlines are the changes. Do we like it as it is, and would we like to approve and adopt the revised document in front of us?
I like the revisions. I move to approve or adopt the policy given the underlying revisions.
All right, all those in favor? Aye.
Aye.
Any opposed? All right, passed unanimously. All right, moving on to our fourth item. Introduction to annexation. This is just simply discussion and presentation of information. The Planning Commission just asked for a very rudimentary primer of what this looked like, and that's all this is tonight. There's no action, there's no plans for annexation, there's nothing. Just I want to get that on the record very clearly.
Have some grant funding to explore, what annexation might look like for that area A, in terms of doing some public outreach, and a preliminary plan for services, which helps the city sort of do a cost benefit analysis. So we do have some funding to explore, and that's a very small area. It's almost kind of an island, and so it makes a lot of sense, and it's kind of a nice test case to think about annexation in the future. I think we've talked a little bit about annexation as part of the general plan update. My opinion is that I think annexation might be necessary in the city to remain viable. And so I think, it should be talked about, and sometimes it's backward. So, I think that public outreach and education is important. So I think this is just, like I said, it's just an information and primer for you guys, for the public. Some people looked at the packet at least. And, if there's questions, I can try and answer them, or I can bring you back answers, or if you want additional information. The staff over at LAFCO are super helpful, our local LAFCO. Very helpful.
Thanks. Any questions from the commissioners for Trevor?
I have a few questions. In our case, does the coastal commission have much input other than through the CEQA process?
That's what's really, that's fascinating. Apparently LAFCO is not subject to the coastal. So, and I think that's really interesting. The city of Eureka annexed, I think it's referred to the break cut.
Right.
Yeah, north, like to the Simpson, old Simpson mill. And the coastal commission was opposed to that, but LAFCO. Very interesting. But what the coastal commission would have authority over is approving the zoning designations as part of the city's. But once it's in the city, they can't just say, don't approve zoning, they have some.
So I just had a couple of general comments. These were, I really liked these sections where they talk about tips. And obviously the most important tip is don't do anything until you talk to the local LAFCO. So it's pretty straightforward there. I was a little surprised though that there is such a thing as an island annexation. I was thinking that was not, I thought it had to be contiguous, but I guess not.
Well, so there's a couple different types of islands when they talk about in here, and one, there's something like the water treatment plant. So that's the exception for a non-contiguous annexation, is if it's city-owned infrastructure, basically. So the water tanks and the water plant are actually within city limits. The island, I think that what this talks more about is basically county land surrounded by city. And area A, I don't know if it qualifies, but it's not contiguous to the county. It's completely surrounded by city, Caltrans, and Rancheria.
Yeah, maybe I misunderstood when I read about that, but I thought that there were enough exceptions that it almost meant that almost anything could be an island and still be annexed if.
That's not my understanding. I didn't actually read through this in detail.
I feel like I had that interpretation when I read it, but then read it again.
Okay.
And it became clear that that was not the case.
Well, I guess what I was, one of the things is that we're limited going south along scenic because of the Rancheria.
And I don't think the city wants scenic drive.
Well, that's another issue. Yeah, right. But, and using that same definition, there are parts like on up West Haven that I'm not sure, with the freeway, if they would be eligible for annexation. But anyway, that couple of comments.
I think, and we did, the LAFCO did just update the city's, I should have given you links to that. I think you've seen it as part of the general plan, but the municipal service review and the sphere of influence. So I worked pretty closely with them on that. They adjusted the sphere of influence slightly, but it's really areas A and B that are within the city's sphere of influence, and those are all contiguous. So I think those are really the only areas that, and C. So C is an anomaly because it's not currently. That's the North Patrick's Point Drive. That is currently not served with city water, but they'd love to have city water, and that area would be significant revenue generating for the city. So there's non-monetary reasons to annex and not annex, but, so it's interesting. Residentially of something like this area A, Langford Road, might be a monetary loss for the city. Until and unless there's some additional development. But there's some benefits in terms of population, housing, having ADUs and count that housing towards the city, having more people to serve on the city council. So it's, and so I think that's kind of, one of the next steps I want to work on is some kind of public outreach materials that talks a little bit about some of the pros. Gives them a chance to serve on city council instead of some people.
Has this information been passed on to the city council?
No. But I've heard they've expressed an interest. That hasn't passed down to me, but I figure it's coming. So, you guys have expressed an interest. I think the city council has expressed an interest. So, no, I haven't given it to them, but there's no reason not to. It doesn't even, I can just send it to them. It doesn't need it.
I was just wondering, is it appropriate to have this as an agenda item on our meeting by this month with the joint?
But not because it's not STR related.
Yeah, I know it is.
So would it be if there's zoning changes?
Well, it's a little, I don't really have time to prepare something, significant for that meeting.
Well, I think my opinion is that we should at least bring it up that we have Trevor's put this great package together for us. And oh, by the way, you ought to get your act together and start doing something. My words, not the planning commission.
But, and I think, we don't want to just jump on having a public meeting because I think we want to do it thoughtfully, but we need to get public input too.
I guess it seems to me like it might be difficult to get the public, unincorporated public. With this. Most people that you talk to, glad that they don't live inside the city. Yeah.
Sure, but they don't.
No good reason, just.
Well, I was gonna say, they don't necessarily understand the pluses and minuses.
Sure.
Is one reason for that, and that's why I think, thoughtful outreach and, I don't know what kind exactly of outreach it is, but a little bit of education, some discussion, so that they can make an informed decision. But yeah, no, I think that's going to be an issue. If everybody already has city water, there's not a huge obvious incentive.
I had a couple just questions / thoughts, generic. Are there any areas that there's a section here that talks about when it involves a special district being either annexed, and it made me think of, and they may not technically qualify as a special district, but we have CSA 4 parcels adjacent to us that we are not part of. That's the county service area, right? And then there's also West Haven CSD. Are there parcels that you know of within our sphere of influence that currently receive water from West Haven CSD?
No, they do not. The city's water service area and West Haven's water service area are not contiguous.
There's nothing up West Haven Drive in that sphere of influence. Okay. And then do you have, I was just trying to, the section on pre-zoning was interesting to me. And I was scratching my head wondering how would a city pre-zone an area that's not part of the city yet? Would it be as simple as, hey, this section would probably be UR, SR, and then that's it? Or is it, or do you not know? It was just very.
I think, we would, I believe how it works is the city would adopt an ordinance, zoning those parcels. SR would make the most sense probably. And we'd have to do some analysis comparing existing county zoning, city zoning, all that. But the ordinance wouldn't go in effect until annexation.
Laying in wait. That's all I had. Anybody else? Anything?
Yeah, the section on disadvantaged unincorporated communities. I guess I caught my eye. It's like hard to define what a community is of anything surrounding Trinidad, given how low density it is. I didn't know if the Rancheria counted as like a community that we would be adjacent to and how that could potentially affect that, but
If the Rancheria wouldn't, they might have a disadvantage designation, but it wouldn't because the city couldn't annex Rancheria land. But parts of West Haven are sometimes a disadvantaged community. There's different levels of, is it census tract, is it zip code? And there's different ways of looking at that. The municipal service review that LAFCO did has a discussion about disadvantaged communities. So yeah, parts of West Haven could be considered disadvantaged. I'm not sure there's really anything that would force the city to draw a bigger circle. We're just looking at, like Hill Creek Lane or.
is that something that's already mapped? Or designated, I guess I should say.
Yes,
Yeah.
yes.
Anything else on this agenda item?
Thanks for putting
Yeah.
it together.
Thanks, Trevor. Sure. Yeah, I'll definitely mention it at the joint meeting. If I forget, please feel free. Yes. All right, moving on to the rest of our agenda here. Sorry, public comment on the introduction to annexation. I apologize. I'm going to miss that before we move on. Is there any members of the public online? Zoom world, not seeing anybody raising a hand, unmuting. Okay. Commissioner reports. Any commissioner reports? The only question I had, just wanted to touch base. I will not be present. It's not really a commissioner report, but I'm not going to be around for the February meeting. I don't know if anybody else is going to be absent for that meeting. I just want to make that known for quorum purposes. I'll be traveling.
I'll be doing this.
You'll be gone? No, there's
I'll be
quorum.
here. I'll be
Okay.
here in February. I will not be here next week.
Right, at the joint one, yeah. And that's the other thing, making sure everybody, I don't know how often, I'm not always in my city email, I don't have it on my phone, but there is the joint meeting coming up. Make sure people are aware of that. I set that out. Just and thank you, Trevor, for bringing that to our attention. It was making all the way down to us, so we'll try and be there. Any other commissioner reports? All right, staff report, anything else for us, Trevor?
And I guess I just remind everybody to, we should probably, staff take a head count before each meeting, but please, if you know you're gonna be missing a meeting, let us know as soon as possible, so we can plan for that kind of thing. We do have some applications coming up, and especially if someone has to recuse themselves, then. Staff report. Keep them very busy. We do have a meeting. We rescheduled our meeting on the Van Wyck Trail with the Coastal Commission for tomorrow. So we will be talking about Van Wyck and Axel and Green Trail. So this was very good to get clarification on what those letters mean. Commission. About next steps. So we'll be meeting with them. Otherwise, I've, working on some permit applications, working on the REAP grant tasks, which includes kind of revamping the application forms and developing some FAQs for the website, annexation study. And then continuing to work on the OPC, so the Coastal Resiliency Project and hazards planning. I did just get comments back from the Yurok tribe on the cultural resources element, so I can get back to working on that. And LCP grant tasks, so lots on the plate. I don't necessarily have, a lot lined up, ready for meetings coming up, but I have a lot on my plate and it will be coming. Later, hopefully.
All right. I did have one other thing, sorry. It's Form 700, whatever it is, the annual disclosure season, just to put a plug in for that, for all of the commissioners. If you have not done it online, I highly encourage you to do the online version because I have, and you just go online and basically say, yep, same as last year. And it's very easy filing. So reach out to Gabe, I think is our contact here at the city, or maybe Anton. I'm not sure who's the expert on. Okay. With that.
Provided paper copies for everyone.
Okay.
It's not done this yet.
But you should have gotten an email from the PPC.
Yeah, the email came out pretty close to the first of the year. I think it
Yeah.
popped into the inbox.
So
So
if you didn't check your junk folder or.
Do they still require a login?
Yeah, I think you have to have a
Password.
username and password, yeah.
yes.
That's always been my problem.
Yeah, I
is
had to
never
reset
found my
mine.
password.
I think if you, there's a reset option.
I'm sorry.
It won't let you reset your password?
It will. I had to do it because I couldn't remember mine where I wrote it down last year.
You reset it.
Yeah, once a year, basically I reset it and then forget where I write it down. But yeah, on
Does it?
the
Okay.
website, yeah, there's an option because
I just had to file manually last year because I couldn't get it to work. Okay.
but
They just hit me with a penalty from 2 years ago where it was a little bit late. And when I first got into this and it's $100.
wow,
So
They find you?
get it done.
no kidding.
Well, did you ask the city to send a letter?
I talked to Gabe, yeah,
Okay.
we talked about it. So,
I know.
price of volunteering and hopefully it'll go to their politics.
Wow.
They've sent me letters too.
You got on?
Yeah.
All right, moving on. Anything under future agenda items that anybody would like to see? Or we've got a
We,
fairly.
in our last meeting, expressed interest in getting together with the STR committee to discuss the ADU ordinance, right? Now,
We're doing that next week.
so it is on the agenda for
Yeah.
next week's meeting. Okay. then I should
That's
pick up
probably
that,
the main
packet.
agenda. I think.
Okay.
Is that packet out yet?
Um,
Not yet. Okay. This end of this week theoretically, right? Okay. After your meetings, right? All right. Well, then with that, motion to adjourn.
So move.
All's in favor? All right. Motion is adjourned. Meeting is adjourned. Sorry.